The choices in the status quo, the proposed plan vouchers will be implemented by schools because it's an acceptable means to integrate schools conservative forcibly combined with minority groups in order to make that happen. All of our evidence is on point about why that would be legitimate. The impact is that school choice movement will turn students into consumers, where education is just another product to be bought, turning democracy into consumption, deracing, declassifying individuals, and shifting blame onto the individuals for creating notions of undeserving poor. Minority flips the entirety of the case for because it shifts the blame then onto the black students. Also, minority students also implements a system in which they can be blamed and places the onus upon them to be the subject of the change. And the impact of that straight turns the case for a few reasons. One, it turns the racism impact will lead to more resegregation, and also leads to a system in which they gave them these rights and they failed to have the rights. Also, the consumerism turns back to biopolitical control arguments about how people are warehousing, people are disposable. This argument makes them disposable by saying, here's your one shot, you get $2,500 to make it happen. If you don't, then you become, it's justified for us to commit whatever atrocities more upon you. Line by line. They have no arguments about, specifically about vouchers. Their only argument is, their only offense is the ICCP voucher, which we'll answer. They say, first argument is no, you can't solve it. Even if we win the vouchers, worsen inequality, you can't prove the precedent of the plan actually can solve it. Vouchers are the perfect response to desegregation as long as everyone has the ability to choose their school. It becomes more difficult for minorities to argue that discrimination is present. Vouchers make it harder to convince courts that discrimination is present. Our evidence argues that vouchers and inequality becomes ingrained in common sense. Vouchers perpetuate the notion of common sense that creates the notion of undeserving poor. Next is that they can see the conservatives control the education, which means that even if the conservative forces will control the educational decision, will win after the plan, they'll push to more vouchers as a solution to desegregation, as well as turning back the effects of the plan. Next, vouchers become constitutional. The government removes constitutional problems with vouchers in the status quo because suburban schools won't accept minorities. Many courts will declare vouchers constitutional. This builds in uniqueness to at least its erosion down to. The Supreme Court is about to decide over the constitutionality of school choice, but it's doing so with a particular blindness to the politics of school choice. And arguments on February 20th, the majority of justices seem to agree that Cleveland's voucher program would be constitutional if low-income parents had a meaningful range of schools. Next is that Cleveland proves a related little A and briefly cities follow on desegregation plans with vouchers. Rosenthal too. In Cleveland, today's battles over school vouchers are inextricably connected to yesterday's battles over racial desegregation and equality of educational resources. In 1995, a part of the lawsuit filed 20 years early to desegregate Cleveland public schools. Federal court, when a school district is in response, state control. In response, the Ohio legislature adopted a voucher program that pays up to $2,250 per year for local students from kindergarten through 5th or 8th grade that choose range to participate in public and private schools. Next is that vouchers be the remedy. This is Lawrence in 2001. As a remedy to judicial created segregation case, the remedy the court hands over to the chief state officer the power to run the Cleveland school district, and then the state legislature adopts its section and gives the remedy to parents of taking these vouchers. Next is that Kansas City, your example, proves our late vouchers are used to fund desegregation in a sense where they're blocked by interpretation of the 14th Amendment and more uniqueness. And 2000. Consider the Kansas City where the federal court for the one white students was able to affect the desegregation of funds. This effort they asked the court to order the Kansas City public school system to issue vouchers siding with the ACLU. School board of the judge refused to vindicate the plan's right to equal protection under the 14th Amendment, which proves that their plan that it will be harder for minority students to win cases in the Supreme Court, ultimately rolling back all their desegregation argument, all their racism arguments if they can't win that desegregation is actually happening. And next to that, Boston proves this is minimum 99. Choice can refer to the modest opportunities for parents, guardians to seek the enroll child in one handful of specialized magnet schools within the public school system. Choice within the public school system also might involve limited cross-district enrollment, such as the MECO program, often in Boston, enable inner-city residents to enroll in participating suburban schools on the basis. Next is that the backlash link, which they're not answering, is that conservative forces will co-opt their plan in order to push vouchers to Apple majority testify. Neither of the economic or moral elements of the pre-voucher argument can be totally set apart from the marginal genesis in the struggles over racial segregation, the bus into cheap integration, the fear of the racial identity plays a significant role in this discursive construction of the problem of the public school area and the political backlash against many of the public choices of the civil area, including school desegregation. Now, their next argument is that Supreme Court will strike down the ICCPR. Ending de facto segregation is key to solve the ICCPR. First of all, our counterplay will be assaulted. One, in the long term, in which after housing patterns change, the schools will be integrated. Secondly, is that our counterplay text says that the Supreme Court will strike down de facto segregation, but in housing, which means it will still solve for the ICCPR advantages. The reason why the counterplay can't do that as well. Also, is that turning international law as bad as the U.S. judicial independence key to preserve moderation in domestic policy and beneficial genocide is Del Hunty in Ohio. The court's recent turn toward international law and constitutional application includes a revolving life, every decision monarchy was followed by fascism, socialism, communism, fascism, communism, which were views to some extent, were adopted by regimes that murdered millions of the Supreme Court of the 30s and 50s, looked to the decision of the Nazi Supreme Court for guidance, while the stability and gradual changes of American political philosophy may have prevented the United States from viewed as progressive, yet they have kept the nation under pursuing ideological extreme that resulted in disaster. Some moderation in American policies in March toward written constitution, the ideology resulted in oppression, domestic population, inter-European warfare, and the death of millions. Also, is that our impacts are bigger. We'll argue that the disposability of population will return. We'll argue that we turn their advantage. Also, that it impacts the overall direction of race relations in the United States and its race relations with other people, which is the root of genocide. Also, is that choice makes discussion of equality and justice more difficult. Choice will be used as a justification for inequality that's power in 2001. Choice is presently constructed in this society is unfettered good, as such we implicitly assume that more choice, the better, and that we live in a choice of unlimited choice would be ideal. The view of choice used in our society as justification for continued racial subjugation to obscure the ways its structures and systems reproduce racial inequality. Choice in a social environment such as education is often said of a relationship and power and may justify by other norms. Choice is particularly suspect history of the school context. Choice was used after Brown and many southern schools tried to avoid the reaches of Brown, maintaining the subjugation of African Americans under various choice schemes. Counterpoint. Look, you fundamentally misunderstand our counterpoint. We don't fiat the people move. We only change the laws, change the current discriminatory housing laws that force them to live in certain segregated areas. Next is not an abuse of fiat. We don't articulate. We don't articulate how we don't. Yeah, we have. Okay. First is not an abuse of fiat. One tax checks having all parts of the counterplay exists with one tax checks by a few things. One, no contradiction to having all the play within one tax prevents the ability for contradiction because it would move the entire counterplay act. And next is that multiple worldviews. There's no shift between different worlds because it's a consistent advocacy of one worldview that exists in the status framework. Next is that there's no abuse just because they exist to solve different things doesn't mean they are abusive. They're just different ways of solving back the case. And next, real world standard is arbitrary just because Congress wouldn't pass multiple policy together doesn't mean we can't. Congress isn't bound by time and theoretical constraint. So comparative and debate is determined. It also is that unconditionality solves all their arguments. They're not arguing that we shift. We don't fiat the ability of people to move places. Next is that all of our solvency advocates talk specifically about changing housing laws, which means that we do have solvency, which is the only requirement they set forth for not meeting abusing fiat. Next. They say permutation to the counterplay. First of all, this is hopelessly separate because our counterplay is fundamentally different in the way we change the mechanism to solve. And we don't overrule Milliken, which is another reason why it's not competitive. Next is the due birth motivation. First, it still links to the disadvantage because it still radically overrules Milliken and changes the way in which conservative forces can appropriate education. And also, it can only start to co-opt the counterplay because they can then use their newfound power to overrule housing regulation, which is going on in state court. Next is the counterplay leads to backlash. First of all, there's no reason why this is the reason not to do the counterplay. The housing integration results in fundamental school segregation. Post-Brown desegregation program wouldn't have been necessary if housing was integrated into Orfield 2006. If the federal government has not segregated public housing or tenants of public housing, mandatory busing to segregate public schools have been necessary because of housing discrimination. Blacks and Latinos who left the city often end up at-risk segregated community characterized by older housing stock, slow growth, and low tax base and resources to support public schools because the concentration of effort and distress racially segregated cities and inner suburbs. The majority of poor Black Latinos live in poor neighborhoods and attend poor schools. Next is that housing policies are the underlying source of segregation, which means that counterplay solves this. Only Ricky's does more. Policies directed to the country and the educational system will may reduce segregation directly, conflicting with the growing movement to decentralize and more manageable schools. Convert school segregation is equally important to convert its underlying residential segregation. The first is housing assistance program to increase opportunities for low-income families to move from the inner city to the suburb. The second is to promote inclusionary zoning so the suburbs to provide a fair share of affordable housing. We need stronger enforcement of anti-discrimination laws. They say that schools will be able to impact this. All of our evidence speaks to how it does it. First, they say plan is key to contact. So first of all, housing would be able to do this and do it in less insidious ways. Across the case terms, they say that lending institutions prevent housing. That's the things that we're trying to change. We shift those discriminatory laws.
Okay. First question.
Yeah.
You said at one point that the counterplan solves for the ICCPR because in the long term schools will get integrated.
Sure.
So when do schools get integrated through the counterplan?
Our argument is that housing changes in housing laws in effect changes desegregation.
When?
I don't know.
Okay, so the first act of the counterplan is to change housing laws, and at what point? Like, can we get a time frame here about when desegregation would happen?
I mean, people would then move.
It's a slow process.
Right. Can I get a time frame? Like, are you saying?
Well, I don't know the time frame, so I can't really give you.
So here's the reason why. The reason why I want to know this is because if it's true that eventually your counterplan leads to school integration, then all of your integration terms link to the counterplan.
No.
How is that not true?
Okay, our case terms make a very specific distinction between the way a forced integration and a slow integration.
Okay, where does it make the distinction that overruling the Millikan decision equals forced integration?
Every piece of evidence talks about how
your evidence that's specific to the court
imposed solution on inter-district remedies are bad.
Okay, and it says inter-district remedies specifically. Because I'm pretty sure that if you made all those kinds of really cool nuanced arguments about Millikan, I would have answered them as much.
Okay, we'll win that housing is a better form of integration than schools, which is what our case terms talk about.
Okay, so you still don't know exactly. I just want to know if you do or do not lead to integration. You say as of the Twin Cities. Okay, that's cool. Next question. It's okay. I think I got it. Thank you. You made a couple of arguments on the counterplan. Also, actually no. I wanted to ask this question on the choice dissent. Oh, the first card that you read that you give uniqueness to the link. Can I see that piece of evidence?
I think your partner has them.
Okay. No, it was a 2NC card. First 2NC card.
First 2NC on the.
On the choice dissent. While you're looking for that, the specific examples that you give for vouchers as a remedy, those particular areas say that because of blocks on the 14th Amendment, they haven't gotten vouchers. Is that correct? Okay, so
you do your plan via the 14th Amendment. Our evidence is specific to how, if they do have a choice then of choosing what school they want to go through, vouchers would be the remedy.
Where does it say that the choice would happen after overruling Millikan?
All our link evidence talks about how vouchers.
Your link evidence is talking about how minorities will push vouchers and desegregation in general. Where does it say that if we were to overrule the intent standard?
The evidence that I read in the 2NC says that when choice is given, then the barriers of the Supreme Court are lifted.
What choice do we give when we just redraw district lines, I guess, is
You're giving choice to those individuals. You don't. This is our whole point in the...
Do you read any evidence that says we don't have to redraw district lines?
Can I answer the question? The whole point of the first cross-examination was that, look, you guys don't mandate a certain...
We're not guys. This is the second time I've asked you, please don't refer to us both as guys. But go ahead.
Sorry.
It's okay. I just need to get that first card that you...
I think you have them because I have link wall.
Okay, there was one and I didn't see it.
I have, it says link wall 1 through 6.
Uniqueness feeds uniqueness to our link. Okay, I'll look.
Yes.
This case right now.
Alright. Yeah, I just have 2 of 6.
2 of 6.
If you find it before the 1 AR, that'd be